One of the core functions of a successful state is to regulate trade, commerce, and industry in a fair and just manner. From times immemorial, from the early Egyptian empires to the great Indian kingdoms of ancient India, we have seen the successful rulers to devote a lot of time and attention to ensure that the trade and commerce is done in such a way which is fair to all the consumers, traders, big and small. Our great Indian text, Arthashastra by Chanakya, is one of the earliest texts on governance and how to ensure fair and free trade. One of the tenets of free trade is healthy competition, where there are no monopolies with power to abuse their dominant positions. In today's video, we shall be talking about combinations under Competition Act 2002. But before that, please take a moment to like and subscribe to our channel and hit the bell icon for notifications. The Competition Commission of India was established with a view of promoting healthy competition in the country and has been given the responsibility to prevent practices having adverse effect on competition, to promote and sustain competition in markets, to protect the interests of consumers and to ensure freedom of trade carried on by other participants in the markets in India and for matters connected therewith or incidental thereto. One of the manners in which the Commission keeps a check on the competition and the market and carries out its duty is by supervising various acquisitions, mergers and amalgamations that take place in the country. The Competition Act 2002 recognizes three kinds of combinations: acquisition of control, shares, voting rights or assets of other enterprises, acquisition of control over an enterprise when the acquirer has already direct or indirect control over another enterprise engaged in similar business as the proposed target, and any merger or amalgamation. Threshold. The Act gives threshold for combinations that will attract inquiry by CCI. At present, these thresholds are as follows. Parties test. The acquirer and target enterprise, jointly in the case of an acquisition or the merged entity, post-merger has either in India the assets of the value of more than rupees 1,000 crores or turnover more than rupees 3,000 crores, or in India or outside India in aggregate the assets of the value of more than 500 million US dollars, including at least rupees 500 crores in India, or turnover more than 1,500 million US dollars, including at least rupees 1,500 crores in India. Group test. The group to which the target entity will belong post-acquisition or the group to which the merged entity would belong post-merger has either in India the asset of the value of more than rupees 4,000 crores or turnover more than rupees 12,000 crores, or in India or outside India in aggregate the assets of the value of more than 2 billion US dollars, including at least rupees 500 crores in India, or turnover more than 6 billion US dollars, including at least rupees 1,500 crores in India. Exceptions have been provided in the Schedule 1 of the Competition Commission of India, Regulations 2011, Procedure in regard to the transaction of business relating to combinations. These are those combinations which are ordinarily not likely to cause an appreciable adverse effect on competition in India. Intimation of such combination under the Act need not normally be filed. Intimation. Such combinations as have been mentioned in the Act have to be notified by CCI by filing the prescribed form with fees within 30 days of occurrence of the trigger event. The Act states the trigger event as the date of approval of the proposal relating to merger or amalgamation by the Board of Directors of the enterprise concerned with such merger or amalgamation or execution of any agreement or other document for acquisition or acquiring of control. The trigger event in case of merger or amalgamation is very clear and easy to keep track of. However, when it comes to acquisition, the trigger event will include any execution of agreement such as share purchase agreements, business transfer agreements, etc., or execution of any other binding document that conveys an agreement or decision to acquire control, shares, voting rights or assets. This includes public announcements under the Securities and Exchange Board of India Regulations 2011, substantial acquisition of shares and takeovers as amended, and unilateral decisions to acquire shares, voting rights or control in case of hostile takeovers. To understand this better, let's look into the Jet Etihad Combination case. In furtherance of the acquisition, multiple agreements were being entered into by the two airline companies. These included investment agreement IA, a shareholders agreement SHA, and a commercial cooperation agreement The form for approval of these agreements was filed within the prescribed time. However, the airline companies had also entered into agreements regarding sale of 3 landings and takeoff slots of Jet at London Heathrow Airport to Etihad and lease of the same slots back to Jet, the LHR transaction, prior to the IA, SHA and CCA. The Commission observed, while it may be open for Jet to sell its slots to any airline to meet its financial needs, the fact that slots were sold to Etihad and the IA incorporates LHR slots agreement as one of the transaction documents, and B stipulates the Commission's approval for implementation of the arrangements provided for in each transaction document, suggests that the parties intended to pursue different steps, including the IA, SHA, CCA and the LHR slots agreement as one composite business combination. LHR sale agreement confers on Etihad the right to terminate the agreement if the IA and SHA are not executed within 30 days from the execution of the LHR sale agreement. Though it was optional for Etihad to terminate the agreement, inclusion of a condition that IA and SHA had to be executed within 30 days to avoid an event of default only indicates the intent of the parties to pursue the IA, SHA and the LHR slots agreement as one composite business combination. Sale, purchase of landing, takeoff slots may generally be treated as a transaction in the ordinary course of business. However, in the instant case, the slot sale were coupled with another agreement to lease back the same slots to the seller and followed by acquisition of equity stake in Jet by Etihad and a wide-ranging commercial cooperation agreement between the parties. Parties consummated LHR transaction without giving notice to the Commission. This means that any agreement or arrangement which is in furtherance of acquisition has to be notified to the Commission within the prescribed time, and no action towards such acquisition shall be taken before getting approval from the Commission. CCI allows for pre-filing consultation (PFC) to parties seeking informal guidance inter alia on determining filing-related requirements, information to be given in the notice to be filed for a proposed combination, and green channel. Pre-filing consultation is an informal and verbal consultation with the officers of the Commission prior to the filing of the notice to a proposed combination by the parties. Parties to the proposed combination can make a request for a pre-filing consultation to clarify their doubts and seek suggestions and guidance from officers of the Commission. There are 3 types of forms for notification of the combination which are available in the Schedule 2 of the 2011 Combination Regulation. Form 1, it is a short form which requires information pertaining to the combination with a filing fee of INR 15 lakh. Form 2, it is a more detailed technical form which parties can opt to file along with a filing fee of INR 50 lakh. The combination regulations recommend that Form 2 should be preferably filed when the combined market shares of the parties to the proposed transactions who are competitors, that is horizontal combinations, is more than 15% in the relevant market, or the combined market share of the parties to the proposed transaction who operate in vertically linked market, that is upstream and downstream market, is more than 25% in the relevant market. Or in the appropriate cases, the Commission may require the parties to notify in Form 2. If the notice was already filed in Form 1, in such cases, only difference in filing fee is required to be paid. Form 3. It is a post-completion intimation form which is to be filed within 7 days of an acquisition, share subscription or financing facility entered into by a PFI, registered FII, bank or registered VCF, under a covenant of a loan agreement or an investment agreement. No fee is charged while filing notice in Form 3. Procedure followed. Either after being intimated of the combination or on the knowledge of any acquisition or merger or amalgamation, the Commission will inquire into whether such combination has an appreciable adverse effect on competition in India. When the Commission is of the prima facie opinion that a combination is likely to cause or has caused AAEC, it shall issue a notice to show cause to the parties to combination, calling upon them to respond within 30 days of the receipt of the notice as to why investigation in respect of such combination should not be conducted. A report from the Director General may also be called by CCI. The Director General shall include in his report the basis of having reached the conclusions therein together with all evidences or documents or statements collected during the investigation and analysis thereof. After receiving the response of parties and report of DG, the Commission will form a prima facie opinion on whether the combination is likely to have AAEC. If the prima facie opinion is affirmative, then it will direct publication of details of the combination for bringing the combination to the knowledge or information to the public and persons affected or likely to be affected by such combination. Then the Commission may invite any person or member of the public affected or likely to be affected by the said combination to file his written objections. Also, the Commission can ask for such additional information from the parties to the combination as it deems fit. After this, the Commission will form its final opinion on whether the combination is or is not likely to have AAEC. If the combination is not likely to have AAEC, then the combination will be approved. If the combination is likely to have it, then the combination can either be rejected altogether or suggest a suitable modification to the combination for eliminating the adverse effect. The parties can accept the modification or submit amendments to modifications proposed by CCI. Where modifications are accepted by the parties to combination or amendments to the modification are accepted by CCI, the combination will be approved subject to such modification or amendments to the modifications. The parties to the combination shall, upon completion of the modification, file a compliance report for the actions required for giving effect to the combination before the Secretary within 7 days of such completion. The Commission also has the power to appoint agencies to oversee the modification to the combination as has been accepted by the parties. Where the parties to the combination fail to carry out the modification accepted by them within the stipulated time limit, the Commission shall issue appropriate directions. Also, where the parties have intimated CCI about the combination and CCI does not pass any order or any direction, then on expiry of 210 days the combination shall be deemed to be approved by the Commission. Green Channel Route. The Commission, via the notification dated August 13, 2019, introduced an automatic system of approval for combinations through a Green Channel route. The parties to the combination, which can opt for the Green Channel route, have been given in Schedule 3 of 2011 Combination Regulation. This will include parties to the combination that do not produce or provide similar or identical or substitutable products or services, are not engaged in any activity relating to production, supply, distribution, storage, sale, and service or of the trade in products or provisions of services which are at a different stage or the level of production chain, and are not engaged in any activity relating to production, supply, distribution, storage, sale, and service or trade in products or provision of service which are complementary to each other. Once the form for Green Channel route has been filed by parties, on the acknowledgement of the form, they shall be deemed to have been approved by CCI. Where CCI is of the opinion that these parties do not fall under the Green Channel route, declaration filed by them is incorrect. These parties will be given opportunity to be heard before they are dealt with in accordance with provisions for non-Green Channel route combinations. Penalty. Any action in furtherance of the transaction, including sharing of commercially sensitive information before such approval is granted, is likely to be seen as an instance of gun jumping and may attract penalties under the Act. Penalty on failing to intimate. If any person or an enterprise fails to give notice to the Commission of the combination within 30 days of the trigger event, the Commission will impose on such person or enterprise a penalty which may extend to 1% of the total turnover or the assets, whichever is higher, of such a combination. Penalty on false statement or failure to furnish material information. Where a party to the combination makes a false statement knowing it to be false or omits to state any material information knowing it to be a material, such person shall be liable to a penalty which shall not be less than Rs 50 lakhs but which may extend to Rs 1 crore. Looking at recent combinations and decisions of CCI. Zee and Sony. On October 4, 2022, CCI approved the merger between Zee Entertainment Enterprises and Culver Max Entertainment, that is Sony, with certain modifications. Zee TV and Sony Entertainment Television are the flagship channels in Hindi general entertainment. The two players have a combined viewership share of 36% in Hindi general entertainment, according to year-to-date data from the Broadcast Audience Research Council India, sourced from the industry. Under the terms of the arrangement, Sony will hold 50.86% stake in the merged entity. The promoters of Zee will hold 3.99% and other Zee shareholders will hold 45.15% stake in the combined company. The two firms are required to ensure that there is no unfair dominance in any market. The formal order of CCI is yet to be issued in the matter. Delivery Private Limited by SVF Doorbell Limited. The proposed transaction entails the secondary acquisition of up to 3.28% of the issued and paid-up share capital of DPL on a fully diluted basis by SVFD. Subsequent to this acquisition, SVFD will hold up to approximately 25.72% of the issued and paid-up share capital of DPL. SVFD is a holding company set up to hold its proposed investment in DPL on the behalf of SoftBank Vision Fund LP, a venture capital fund focused on making long-term financial investments in companies. The Competition Commission of India approves the secondary acquisition in Delivery Private Limited by SVF Doorbell Limited under Section 31, Subsection 1 of the Competition Act 2002. BNB Paribas Mutual Fund and Bank of Baroda. The parties propose to amalgamate BOB Asset Management Company into BNPP Asset Management Company and BNPP Trustee Company into BOB Trustee Company. BNPP Asset Management Company is the dedicated AMC for the BNPP Mutual Fund and acts as the investment manager of the BNPP Mutual Fund. It provides portfolio management services and advisory activities. BNPP Trustee Company is the trustee company of the BNPP Mutual Fund. BOB Asset Management Company is the dedicated AMC for BOB Mutual Fund and acts as the investment manager of BOB Mutual Fund. BOBTC acts as the trustee for BOB Mutual Fund.